Hello. Selling property from the estate, particularly real estate property from an estate succession, might be a tricky adventure or might be simpler than one thinks, depending on what's going on. And let's have a look at that. So, what happens? Somebody unfortunately died, and there was some property left. In simpler situations, it's just some family house, which goes to one heir by way of particular title, for example, or by way of like a residual legacy, a universal legacy, and that same person is the executor, liquidator of the estate. That's one thing. Another thing, if the property is left to more than one person, and not all of them are executors, and it might be left by way of particular title, particular legacy, meaning that it should be delivered from the estate before everything else is distributed to universal legatees, after creditors, but before universal heirs, basically. And there might be more properties of that kind, and some of them might be charged with some sort of hypothec or servitudes or just other rights, sometimes even like significantly complicated rights like usufructo emphyteusis, for example, or some other like long-term lease. And sometimes an executor who, usually under pressure of other co-heirs, usually relatives or friends, but normally relatives, that executor, the liquidator who rushed to give away that property from the estate, to transfer the property to heirs or to sell the property, that executor might find him or herself in trouble. So, what should be looked at? If there was a will, mostly, in most at least notarized wills, the executor, the liquidator, is provided with full administration of property, meaning that technically the executor, the liquidator, does not need to obtain heirs' consent, heirs' permission to move that property, to sell, to transfer that property from the estate. But if there was no will, or if the will was signed before witnesses, or it was a handwritten will, chances are that this full administration was not mentioned. Or there is no will, so therefore no full administration. Therefore, the default regime of simple administration goes by the Civil Code of Quebec, which says that to sell that property, the liquidator has to obtain consent of the heirs. And if there is no such a consent, as in any other situation when there is no such a consent, the liquidator should go to court asking for the court's authorization to sell before proceeding. Otherwise, there might be responsibility. The property might belong to the estate not in full. For example, it was a family residence, and the deceased person was somebody's husband or somebody's wife. So there is an issue of family patrimony, meaning that even if the property was in the name of the deceased, there might be a situation where half of it legally belongs to the other spouse, or at least like should be delivered, or at least value should be delivered. And often this is not taken into account when the will is drafted or when the liquidator is doing his or her job. And therefore, again, there might be responsibility because it should have been delivered in part to the widow or widower. but it was already sold or moved somewhere. There might be litigation, there might be a claim and civil responsibility, and so forth. Also, let's say half of it already belonged by the notarial deed, 50-50, or in some other proportion to somebody else, and the heirs of the estate push you, or not you, but each other, to sell, but the other co-owner doesn't want to sell. And one thing if it's just a simple co-ownership, but what if in the co-ownership agreement there is a stipulation postponing the possibility to sell to some significant time, sometime, like usually it says something about 30 years, and who knows when it was signed already, when it was renewed, if it was. Or maybe there is some stipulation there saying that the conversion to condominium is planned, especially if it was a duplex or triplex, for example. And again, any rush with an attempt to sell it might bring everything into like long-lasting trouble. Also, even if the will says clearly that it should go, well, for example, to the niece of the deceased, but there are creditors to the estate, and if the liquidator, who is coincidentally that niece, rushed to transfer the title to herself by way of particular title, and then it appears that the estate doesn't have enough money to pay the creditors, then again it would appear that the transfer was done unlawfully, because it only, by law at least, should have been done when the claims of the creditors are satisfied. Because if there is now enough assets in the estate to satisfy the creditors' claims, then in part this property left to somebody by particular title should be also sold, and the assets should be used to a certain proportion to cover those creditors' claims. So again, there might be that the liquidator faces him or herself breaching this duty to keep enough assets in the estate to pay the creditors. One formality that many persons bypass, and if it all goes well, usually it doesn't bring significant consequences, but technically it might. Because again, one of the creditors is the state, the government, like taxes. And if the property was moved, transferred from the estate without obtaining specific clearance certificates allowing that, certifying that the government doesn't have any claim, then the liquidator, the estate, together with heirs, might face legal conflict with the government about that. Also, there might be tax issues, like tax amounts, which are not properly calculated, and later on it would appear that there was a claim that would just touch that property. And again, most of liquidators, executors are not professionals, so who knows if the accountant was involved or not to calculate all that, to submit all those taxes and property taxes. Maybe there was a debt on property taxes, like again, a hypothec of sorts. So there might be some claim against that property, which follows the property, like hypothec again, like some kind of servitude. There might be some caveat in the co-ownership agreement, as I mentioned previously. So there might be issues and issues and issues. Therefore, as always, it's very much advised to consult a notary, a lawyer, before you transfer the property from the estate anywhere. Sometimes the estate even bypassed, and people transfer it directly from the deceased to the heirs. And again, if everything is okay, usually it's not a big deal, but if there is some sort of a claim, that again might bring problem upon the head of the liquidator, the executor, first of all, but also upon the head of that heir who received that, or sometimes already upon that buyer who already have bought it from that heir, if there are many ifs, but still there is a possibility. And therefore there might be a claim from buyer against the seller, which is an estate or an heir, and so forth and so forth. So despite of that idea that everything is clear, like my grandfather died or my uncle died or aunt, and it says that it should go to me, so I simply take it, goodbye. No. There are possibilities, there is a potential for a legal problem. It's better to verify in advance. Thank you and have a nice day.